The controversial case of Terry Schiavo gripped national headlines for 7 years between 1998 and 2005. But death with dignity, or DWD legislation, goes all the way back to the turn of the century. Apart from Schiavo's case, there have been many well-known instances of people choosing to medically end their lives. Opinions have changed over the years, with 37% of Americans supporting a physician-assisted death in 1947 and a whopping 73% supporting it by 1993. But it remains a complicated issue, with plenty of pushback from both the government and religious groups. So, today, we're giving you all the facts about the Terri Schiavo case and the history of right-to-die laws in the U.S. But before we reach that light at the end of the tunnel, why don't you reach for that subscribe button? Then let us know in the comments what other legal issues you want to hear about. For now, you gotta fight for your right to, die. The 19th century was the Wild West, both literally in historical contexts, but also metaphorically regarding medicine. Medical innovations of that period mostly included bloodletting, leeches, and chemicals that are now illegal to own for personal use. However, as medicine began to evolve, the inventions of morphine and chloroform had doctors realizing that they could finally do their jobs without causing mind-numbing pain in their patients. It was a pretty exciting time. Doctors were then able to use these new medical developments to offer a physician-assisted passing. That is, until 1885, when the American Medical Association officially put the kibosh on any further mercy terminations. Morphine and chloroform could still be administered to alleviate pain, but they could not be used to page the Grim Reaper, so to speak. In 1938, the goal of changing laws about assisted terminations was put forth by the ESA, the Euthanasia Society of America. That's euthanasia, not Youth in Asia, the early 1980s UK anarcho-punk band. Over the next 3 decades, the ESA tried to promote the idea of dying with dignity, but it seems a lot of society was not down with DWD. So, instead of focusing on the macro, the ESA pivoted in the 1960s to individual rights to refuse life-saving medical treatments. This saw a bit more progress. Working with attorney Louis Kuttner in 1967, the ESA was able to establish the first living will, a document written by a patient that specifies what medical treatment they wish to receive when they are unable to answer for themselves. This is a common concept today, but it was entirely new territory back then. By 1970, about 60,000 living wills were distributed by the ESA. The legal debate around DWD has caused uncertainty throughout the 20th century. Some officials pushed for a painless death for incurables, while others wanted harsher penalties for anyone who attempted or assisted in terminations. This was the case in 1911, when a woman named Sadie Marchant was feeling the pain of tuberculosis. A member of the Shaker colony, Marchant asked for assistance in shuffling loose this mortal coil. 2 Shakers helped Sadie realize her wish, only to be apprehended for murder after the fact. While the case was ultimately dismissed, it did turn a spotlight on the uncertain legal status of anyone who knowingly assisted in the cessation of another's life, even if that person asked them to do it. Karen Ann Quinlan went to a party in 1975 and helped herself to a few gin and tonics and a Valium to wash it all down. This near-fatal mixture would send Quinlan into a coma from which she would never awake, and kicked off an important headline in the argument for the right to die. Quinlan's family wanted to remove her respirator after discovering there was no chance she would ever recover. However, the doctors were afraid of repercussions, including potential homicide charges, so the family took the case to the New Jersey Supreme Court. One unanimous ruling later, it was established that an individual's right to privacy does extend to removing life support systems. This meant that Quinlan's father should act in the best interest of his daughter, rather than letting the courts or doctors decide for them. Additionally, the ruling said that whoever removed the life support could not be criminally liable for what happened next, since the passing was expiration from existing natural causes. In other words, the accidental overdose is what ultimately took Quinlan's life. The life support systems were just buying her doctors some time, tragically to no avail. Quinlan's respirator was removed in 1976, but Quinlan would not pass away for another 9 years in June of 1985. Nearly 30 years after that, in 2014, 29-year-old Brittany Maynard got the unfortunate news that she had terminal brain cancer. The newlywed was planning a family with her husband, Dan Diaz, and wanted to spare them the nightmare scenario of having to watch her health decline as she wasted away in hospice care. Instead, she decided to move to Oregon and use the state's DWD laws to finish out her life on her own terms. Maynard said the decision gave her a sense of peace during a time that would normally be dominated by fear and pain. She passed in November of 2014. The Ohio legislature became the first to consider a euthanasia bill back in 1906. At that time, Anna Sophina Hall lived in Cincinnati. Her mother was struggling with a painful terminal illness, and she pushed for a DWD act to end her mom's suffering, garnering support from New York Times columnists and Salvation Army officers alike. Later that same year, Dr. R.H. Gregory tried for a similar bill in Iowa. The British Medical Journal, in response, called him a crank and a notoriety hunter, which are some of the sickest turn-of-the-century burns you can dish out. These early assisted termination bills, eventually known as chloroform bills, never ended up becoming laws. You couldn't get through 90s television without seeing some kind of reference to Dr. Jack Kevorkian, aka Dr. Death. But what sounds like a pretty great professional wrestling gimmick is, in fact, the face of the physician-assisted suicide movement. And also a pretty great professional wrestling gimmick. By 1990, 65% of Americans were fine with physicians assisting in ending patients' pain. That same year, a woman suffering from Alzheimer's disease was assisted in passing by Kevorkian, who traveled the country with his so-called death machine. He probably should have spent more time brainstorming names. They don't write quite as many headlines about Dr. Jack and his big sleep machine. Kevorkian spurred worldwide conversations about the ethics, morality, and legality of assisted terminations. In several cases, he faced criminal charges for the work he did, like when he provided a tape to 60 Minutes showing the process of administering life-ending medication to a patient. While those he helped believed in what he did, Kevorkian was eventually sentenced to 10 to 25 years in prison and was forbidden by law to end anyone else's life upon release. He served 8 years of that sentence before passing from liver cancer complications in 2011 at age 83. Terri Schiavo was only 26 years old when she suffered a cardiac arrest that placed her in a persistent vegetative state in 1990. After 8 years, Terri's husband Michael petitioned for the feeding tube to be removed to end what he viewed as Terri's longtime suffering, but Terri's parents wanted it left in. And what followed was one of the biggest legal battles in the history of end-of-life care, which dominated news segments for several years. Both sides argued that they were acting in Terri's best interests and making the choice she would have made were she able. Terri's parents cited videos of Terri smiling and interacting with them as proof that she wasn't actually in a complete vegetative state, and that more could be done to potentially ease her out of it. The tube was removed in 2001, only to be reinserted 2 days later. More legal proceedings and arguments from both sides saw the feeding tube removed a second time in 2003, but Florida's then Governor Jeb Bush ordered the feeding tube reinserted in a move that the Florida Supreme Court ruled unconstitutional. Apparently, he couldn't get anyone to clap for him back then either. The case made national headlines by 2005, eventually getting Bush's brother, President George W. Bush, involved in the proceedings. Eventually, the state court ruling prevailed, and Terri's feeding tube was permanently removed after having spent 15 years in a vegetative state. She passed away on March 31, 2005. An autopsy revealed that her brain damage was irreversible, with no cerebral cortex function, so she wouldn't have had any awareness of self and was completely blind, disproving any perceived eye contact. Sadly, based on the size of her brain and the loss of neurons, no amount of therapy would have changed her condition. According to the Old Testament, Moses came down the mountain with a stone tablet that read, "Thou shalt not kill." And ever since then, the Catholic Church has firmly applied that commandment to physician-assisted terminations. In 1995, Pope John Paul II underlined this point, saying that the termination of a human person is a violation of the law of God. No ifs, ands, or buts, but there is one area where the modern church has been flexible. Earlier popes, like Pius XII, saw a line between mercy terminations and end-of-life care. Declarations on euthanasia in 1957 and again in 1980 reinforced the church's opposition to the subject of assisted self-termination, but recognized a moral right to refuse extraordinary or aggressive medical interventions to preserve life, such as in the case of a Do Not Resuscitate Order, or DNR. In other words, the church was down with DNR, but not DWD. Washington state voters were able to weigh in on a DWD initiative in 1991, when a proposed law would legalize a physician-assisted finale for suffering individuals. This would allow competent terminal patients to be given a lethal injection by their doctor. Opinion polls seemed close, but Election Day told a different story. The movement failed by a 56% to 46% vote, maintaining the criminality of the act in the Evergreen state. The following year, California voters participated in a similar act, but the act was struck down by approximately the same margin. Oregon led the charge on DWD back in 1994 and was the first to have voters successfully pass legislation. Unlike the earlier attempts in Washington and California, Oregon's proposal allowed doctors to prescribe the lethal drugs, with the onus being on the patient to take them unaided by a physician. Colorado, Montana, Vermont, and the District of Columbia followed suit afterward, and by 2019, Hawaii's DWD law went into effect. It probably won't be long before we see another Dr. Death start making house calls. The physician, not the wrestler. So what do you think? Do you remember the Terri Schiavo case? Let us know in the comments below, and while you're there, check out some of these other videos from Our Weird History.